June 9th, 2022. This is a huge win for our law office in employment, gender discrimination, and retaliation case against a powerful federal agency. Quentin Borges-Silva versus the Environmental Protection Agency. A hearing in New York. This was a case of hostile work environment and retaliation, gender discrimination against Mr. Borges-Silva. And my friends and followers, this is a trial win for Morris Fischer's law office, tried by myself and the client, who was incredible in this case, Mr. Borges-Silva. And the judge finds that the evidence showed that the agency subjected Mr. Borges-Silva to a hostile work environment based on his gender and his prior EEO activity, and then placed him on a performance improvement plan, a PIP, in reprisal for his EEO activity. Now let's break down this case. Mr. Borges-Silva was an environmental protection specialist in the Communications Services Branch, the Office of Pesticide Programs at the EPA. Mr. Borges-Silva was a successful protection specialist for some 16 years. He went ahead, he had excellent reviews. Then what happens is he gets a new supervisor. And the supervisor singles him out of 4 female co-workers who, by the way, all testified in his favor, which we'll get to. His being Mr. Borges-Silva, that Mr. Borges-Silva had an excellent knowledge of his job. He was congenial. He knew exactly how to get along with other people. He wrote a lot of the templates for the job. He was an all-star, in short. The new supervisor, a younger man, didn't see it that way and basically started to pick apart his work product. Now, what did Mr. Borges-Silva do? He was responsible for addressing public webmail inquiries dealing with pesticides and pesticide exposures. He also responded to national press inquiries. So, for example, when the New York Times asked some very critical questions of the EPA about neonicotinoids and their effect on bees in the United States, the EPA looked to Mr. Borges-Silva to respond to those inquiries and to give his advice and to make sure that the EPA didn't look bad. This was a very high-ranking official. This was someone who knew his job. He knew more science than the supervisor. Anyway, the supervisor didn't like it, puts him on a performance improvement plan, and contends that Mr. Borges-Silva could not respond to 25 webmails a day, and also the webmails that he responded to were lacking in content or style or whatever. By the way, this PIP continued for roughly 60 days, and Mr. Borges-Silva was terminated for supposedly not fulfilling the requirements of the PIP. That is what is at stake in this case, heading towards the hearing. And the hearing is 4 days. And it's complicated. There's a lot of science out there. There's a lot of discussion about what it was that Mr. Borges-Silva did, and did he do it correctly. The agency contended he didn't. At the end of the trial, we raised on closing argument, what was the objective evidence to believe the agency witnesses? In so many of these cases, there is nothing but self-serving emails. So-and-so did a lousy job because I said so in email. Where's the product? Where's the work product? How do we know that, Mr. Supervisor? And when Mr. Supervisor had to actually produce the work product, it was clear as day that it was Mr. Borges-Silva who knew the stuff, and it was the supervisor who knew nothing, yet continued to pester and basically prosecute this man. And here's a good example right here. An email, July 12th, 2019, and I circled this part for the judge, where Mr. Siegschlag, who was the supervisor, actually then confers with Mr. Borges-Silva's response and says, yes, you should tell him in this case, if you remain unsure why Amazon took the action against you, the citizen who had a question about Amazon, please connect them with Amazon. And that was what Mr. Borges-Silva had originally told this citizen who had asked this question. Mr. Siegschlag criticized Mr. Borges-Silva's answer. Mr. Borges-Silva then went over the matter with Mr. Siegschlag. Mr. Siegschlag, the supervisor, goes ahead and agrees with Mr. Borges-Silva. That was on the pick, okay? And believe it or not, what really killed the agency in this case was this email that you're looking at right here was not part of the report of investigation. Meaning the EEO investigator says, hey, go ahead, give me all of the back and forth, the email chains, so on and so forth, to gather as evidence. Well, how do we know that the government actually does that? How do we know that the government sends everything in the email chain that's relevant to the case? We don't. Mr. Borges-Silva got a hold of this, though, and bam, this really demonstrated that the agency was trying to cover up this matter and was prosecuting somebody for no reason. There was another really big point in the case. The supervisor contends that Mr. Borges-Silva never told his team leader about a backlog of webmail responses due to a government shutdown. Finally, April 22nd, Mr. Siegschlag documents that he spoke with Mr. Borges-Silva and he spoke with the team leader, and Mr. Borges-Silva did tell his team leader about the backlog. Wonderful. The problem with this was that if you look on this page right here, look at the date of Mr. Siegschlag's EEO affidavit. It's 6 months later. And he tells the EEO investigator the same lie that he brought the case on. The same exact thing. Even though he knew 6 months before that Mr. Borges-Silva had done what he was supposed to do, had told the team leader about it, he confirmed that in writing. 6 months later, in his EEO affidavit, he tells the investigator the same party line that government agencies do. And no matter what, their plan is stick with what we think will win the case, whether it's true or not. And this time they got nailed. Another time this happened in the trial. This was a big moment right here. Under the EPA's policy, this 4711 policy, where someone complains about discrimination from a supervisor, look at what is supposed to happen right here. You're supposed to separate the harasser from the alleged victim. The harasser is not supposed to be giving this person more work to do, because the nature of the complaint is the guy can't do the work as well as he would have because that person is in a hostile work environment. And this was not done. So how does the agency get around that? The judge notes in his opinion, they don't. They have no answer for that. Once the complainant filed the 4711, he should not have remained working for Siegschlag during the investigation. Therefore, his performance during that period cannot be held against him. And that's what the judge found. If you have a case and your company or your agency has a policy of what is supposed to happen after you have complained about discrimination or whistleblowing or something like that, and that policy is not followed, that is a really big development in a case. And that is a piece of evidence that can really, really work against the agency or the company, as there were many. And then we finally got to the co-workers. Okay, all of these women, they were all very honest. They all testified in front of the judge. Truthfully, the judge notes in his opinion they did it at their own risk. They ought to be commended. They were all incredibly honest, straightforward, credible people. And they said point blank, this should have never happened to Mr. Borges-Silva, and it was the supervisor's problem and his fault. And my final point was, what was the objective evidence to believe the agency? Absolutely none. Mr. Borges-Silva was a tremendous client. He still is, as we move on to damages, and they will be significant in this case. Frankly, of the trials I've done, I don't think this one was particularly close. I think this was kind of a wipeout. And the EPA went up against a real juggernaut here a couple weeks ago. An incredibly prepared trial team, an incredibly confident, hardworking, persevering, aggressive, tough, vigorous attack on this agency supervisory chain that got destroyed. We can do it for you. If you have a case right now and you're in the middle of it and you don't like how it's going with your attorney and you may be getting endless bills that may not be going anywhere, give us a call. We work with people to get the results. And while I can't guarantee any one particular result, I can tell you this. The representation we provide here is tough. We care. We want to win your case.